Alrighty. So last session of the day, we're going to, ideally what today is it's filling your brains with many, many things that you want. And that's what tomorrow is hoping to pull that together and to make them into things that you get. So to add to the pile of things that you want or want to know more about, we're going to transition our discussion over into liability. And to do so, we'll have Sarah Clark speaking to us first. Jessica Gunder from University of Idaho is going to come in about an hour and share a little bit with us as well. So we'll have some additional perspective there. And I will just tell you that you're not going to come away with this with a law degree. Wouldn't that be magical? But you'll have at least for me, this is probably like the 15th time I've heard these types of words. And every time I learned this much more. And it just is something about absorption. So hearing these things multiple times is really important and increase that understanding. So appreciate Sarah's willingness to come and speak with us. The time that I gained this much instead of this much was when I heard her recording previously. So I'm looking forward to hearing some of what she has to say. And so I can get a little bit better understanding of that and we can start to place that in Idaho. So with that, I will turn it over to you, Sarah, and you're welcome to share your screen however you wish. Yep.
I will go ahead and do that. Okay, can you see my screen? Oh, looks like, there we go. Can you see okay?
Got it, yeah.
Okay, perfect. Well, hello, everyone. Nice to be with you all, although you are very tiny on my screen, and I assume I am very large in your room. So that dynamic is strange, but I am nevertheless excited to be here with you all today and talking about a topic that no one ever really wants to hear about, which is liability issues. But hopefully, as Heather said, I can be of help in having you have a better understanding of what liability means in the prescribed fire context, and then hopefully getting you excited about some of the changes in liability law that are happening across the country and starting to think about how that might be possible in Idaho. So what I'm going to do today is I'm going to talk in broad strokes first just about what liability is and how I personally conceptualize it in a space. There's a number of different ways about talking about liability, but I have tried to break it down in a way so that it isn't just a huge indemnification paragraph on a page that is very hard to understand. It's something that is more accessible for practitioners. So we'll start with that kind of general overview. Then I'm going to talk a little bit about what I see in Idaho, in existing Idaho code, and how that particular law in Idaho might apply in the case of an escaped prescribed fire. And then we will move into, I think, hopefully the more exciting part of the day where we imagine what the future might look like, were you to engage in some advocacy work around prescribed fire liability legislation. And I'm going to ground that part of the conversation primarily in a talk about what has happened in California and sort of the approach that our state has taken. I'm based in San Francisco to try and address some of the liability questions that we know pop up for folks across the country. So that is my hope for today. And I know that Jessica is joining us midway through, and what I'm going to try and do is have her sort of kick off the imagining the future part. So we'll try to keep this first section to about an hour. I definitely don't have an hour of presentation material, so I'm hoping that we can have some good Q&A that Heather hopefully will help facilitate. So jumping right in. First, for those of you that haven't seen me present before or haven't seen my work, just a little bit of background as to kind of how I got here. I started working in this space primarily by working with prescribed burn associations and tribes on projects. So they would approach me and ask for legal help, either with sort of the regulatory side. So how do I go about getting this permit? When does the California Environmental Quality Act or the National Environmental Policy Act apply? How do I deal with endangered species issues? So those sort of regulatory items, as well as really big questions around liability and governance. So questions like, I want to burn on my neighbor's land, and I'm going to bring some volunteers and also the volunteer fire district and a local cultural fire practitioner. Who has liability if something goes wrong? Whose insurance applies? How do we develop waivers and other agreement structures, especially in these kind of cooperative burning settings? So that was I started working on projects like that about 8 years ago. And then from that work, got sort of recruited or tapped to help out on a number of different policy reforms that we were hoping to see. Those were really spurred first by the publication of a report called Good Fire, which identified a number of the barriers and legislative solutions in California to address to expand the use of beneficial fire, which I define as both prescribed fire and cultural burning. That then was a product that we took basically to the state legislature and said, here are some ideas. And it led into helping to draft multiple California laws on these topics. And I will talk kind of more extensively about those and how we approached it, some lessons learned later in the talk. I then served as part of the advisory group to establish California's Claims Fund, which was a super interesting process, got really into the nitty gritty about like, who should make what decisions, which claims are eligible. We're still going through that process right now, although the Claims Fund has been operational for almost 2 years. And then I worked on some kind of higher level policy and advocacy related issues. So I was involved with the California strategic plan to expand the use of beneficial fire at the state level. And then I served as a subject matter expert for the bipartisan Wildland Fire Mitigation and Management Commission, which looks more at the barriers and opportunities at a federal level. And so that's my background and what brings you here today. And in particular, I have a little note from the Fire Learning Network. So TNC has, I've been working with TNC for about, I think over a year now. I see Emily on the call, to help in this context. So to help other states sort of learn from what California has done and to really think about how we can take some of the things we've done in California, lessons on liability, and apply them elsewhere. So thank you to FLN for supporting this work today. Okay, so I do have to do this as a lawyer, and especially a lawyer that was talking to a bunch of folks in a state that is not my own. This is not intended as legal advice, and it does not create an attorney-client relationship with me and anyone in this room. And I will note that I am not barred to practice in Idaho. And so really what I am here to talk with you today is kind of at a higher general level to talk about some of the kind of academic interests I see in Idaho law and to talk about policy ideas, but not to provide specific legal advice. So sorry for that caveat. Let's move along. Okay, so thinking about liability, and this really gets into the heart of kind of the like this broad topic about like, how do I think about liability? How should you all think about liability? And I think it's really helpful to start with looking at what the different things you might be liable for as a prescribed fire practitioner. And to really think about, okay, if something went wrong, what could I be sued for? Like who might name me in a lawsuit and what could I be responsible for having to pay for? And in this context, there really are 3 different and distinct buckets of potential liability. And the reason why it's important to break these out is that different standards will apply to each of these. And there are different techniques to try and reduce or minimize liability in each of these categories. It's sometimes I think in some of the academic literature and some of other talks I've seen on this, it lumps everything together. And what I think has been really interesting and is important for you all to think about as you think about changing your liability standards is that there are these distinct categories, and it may be helpful to think about them in different ways because you may be able to achieve changes in one but not the other that are still meaningful and important. And I'll talk a little bit more about how that's worked in California in a bit. So to go into what the 3 main categories are, first is what I term participant liability. So this is the damage or harm that can be caused to people that have chosen to show up for the burn. So this could be your landowners, this could be your burn boss, this could be any staff or employees that are showing up as part of their job. So that could involve, depending on which land you're burning on, it could be state or federal employees, it could be tribal employees, it could be the employees of a nonprofit organization that is hosting the burn, or a resource conservation district, or some other entity type. And it could also be volunteers or other bystanders. And so the obvious harm to these folks is either they could be harmed in a physical way, meaning they get injured on the site, or they could have their property damaged. So for the landowner, that could mean that either the burn was too hot or it went in a place that was unexpected. And so there's damage to either real property, either within or outside of the burn area. And then it could also mean like, you inadvertently had damage to a vehicle or to someone's equipment or things like that. So participant liability is, I think, important to start at, because it's one of the places that you all have the most control over. Because people are actively showing up to burn, you get to decide how much liability do we want to owe, or responsibility do we want to owe to one another? Do we want it to be where one party is primarily responsible, and if someone else has loss or damage, then that party is going to pay for it? Or do we want to all agree that because, there is some risk to this activity, we're showing up knowingly and voluntarily, that means that we're going to waive any potential harms that might come to us as a result of it. And I'll say that for many of the collaborative burns that I work on, that's the choice that folks make, where they're looking at a waiver approach to say, look, everyone here showed up, knowingly and voluntarily. And so therefore, if any harm comes to them, that's on them. And we're not going to have people suing each other within the group. But in other contexts, especially, for instance, if you have a burn boss that's running a business and is out for hire, it may be the case that you want that person to be the kind of person that's primarily responsible, even if they cause injury to another party that has hired them or that has showed up to burn with them. So that's the first category, is this participant liability. The second category to think about, and this is the one that I think is in most people's minds, is third-party damages. So this is damage to people that did not agree to participate in your burn. So it might be your next door neighbor, it might be someone further down the road, it might be businesses nearby that are affected by smoke, or a driver that is affected by smoke and causes a car crash. So these are all folks that really had no choice in the matter. They're there as third parties, but due to a variety of factors have ended up being affected by the burn. And this is this third party liability is the place where I think folks get rightfully a little bit nervous and concerned, right? If we start talking about either real property damage, if you burn down multiple houses, that can be a lot of money at risk. And then also, of course, if you were to cause injury to parties that weren't actively participating, that obviously would have pretty negative consequences. And so third-party damages are the liability category that we really think about a lot, and we'll talk about the main ways that folks have attempted to address this. The last category is something that I was not aware of until I started working in this field. Definitely not something they teach you in law school, but is about suppression and investigation costs. So the last category of things you might be liable for is really about what are the consequences of having an escaped burn, and who else might show up and be involved in trying to help get it contained. And so in most states, when either the state or the federal government or a local fire district shows up to respond to a prescribed fire, either one where you have a slop-over event or something that is more, a declared wildfire, a true escape, those entities, typically under state law, have the right to say, here's the bill for that. It wasn't my fault that this burn happened, and so I'm going to turn around after I've come and helped you out and try to recover my costs for having to send out a tanker, for having to send out a fire crew, for having to investigate the causes of the burn. And these costs actually tend to be a little bit more common than the other ones, in that, having a slap over or something where you need some assistance is not all that uncommon. I mean, it's still quite uncommon, but it is slightly more common than like having true damage to a third party. And it can be a significant amount of money, especially if as in California, we have very aggressive suppression techniques. And so sometimes we get folks that are really sending out all possible men and equipment and women to respond. You can get some really high suppression cost bills. So those are the three buckets in thinking about like, okay, if something went wrong, these are the costs that I might have to pay. So we then move along to thinking about what the standards are that apply to these different buckets. And when I say standards, I mean talking about which threshold an activity needs to cross in order for you as a burner to be liable for those three different buckets that we talked about. In most states, we'll talk about strict liability in a second, but in most states, it's the case that even if you cause one of those harms, either participant liability, third-party damage, or suppression costs, even if your fire is the cause of those harms, you are not automatically responsible for paying for that harm. Instead, what the law says is that there is going to be a threshold at which your activity becomes the type of activity for which one would be liable. And this is where we get into language around negligence and the idea and concept of negligence. So in most states, what happens is a burner is liable for those three buckets only to the extent that they are either negligent or grossly negligent in the carrying out of their burn. If they do everything right and they can prove that they did everything right, then they shouldn't be liable. And then that's considered sort of a true accident, and the party that is harmed has to eat the cost. So there's been a lot of academic study and discussion about the different liability standards across the United States. A lot of like 50 state surveys. This comes from one of them from 2017. I know in Idaho, you have some academics that have been engaged in similar studies recently in the Western states. And there's been some conjecture about, do different liability standards create sort of a different culture around prescribed fire? And if they do, could we then change our liability standards and hope to achieve the same results? I think the main reason for this is that folks really look to both Florida and Georgia as sort of leaders in this area. So as many of you probably know, Florida and Georgia have some of the most robust prescribed fire programs in the United States. They have a culture of doing quite a bit of burning. And it seems as though they have sort of more social license or public acceptance of prescribed fire. And there's been definitely some conjecture that part of that is because of their gross negligence standard, meaning that because the state has made it more difficult for people to, or for more difficult, or let me rephrase that. The state has made it easier for prescribed fire practitioners to defend against potential claims of losses. That means that more prescribed fire practitioners want to engage in that activity. And the more we do it, the greater social license we have. So I think that is a good story, and it's an important thing to look at. And certainly we have seen a lot of efforts in this regard. I think it tends to be a little bit simplified. And we only have, a couple of states that have really gone so far as to adopt a true gross negligence standard for all of those different buckets of liability that we've talked about. We'll talk in a little bit about the ways in which California has approached this and some of the pros and cons of going to this gross negligence standard. Just a quick word about the two dark gray states on here, so Minnesota and Wisconsin, that have a strict liability standard. In those states, basically what happens is if you cause it, then you're liable. So there is no threshold. Just as long as there's causation between the activity and the harm, then there's liability associated with it. That obviously creates a disincentive for prescribed burners because they have no ability to come in and say, but look, I really planned as well as I could. I did all of my due diligence. I made sure everything it was done to the best of my ability. In those states, even if you can show that, you still might be on the hook. And so those strict liability states are ones that the prescribed fire community really tries to move around. What I'll note on here, and we'll talk about this in a bit, is Idaho is shown as white, which is undefined. And I think we'll talk specifically about where I think Idaho falls, but this is probably correct because there's some lack of clarity in your law right now that we'll talk a little bit about. Okay, so then now that we've talked about these different thresholds and the fact that they exist, I want to spend just a little bit of time talking about what the different thresholds really mean and why there is a really important distinction between simple negligence and gross negligence. So as I talked about, strict liability, those Minnesota, Wisconsin examples are if the burn caused the harm, the burner is liable. But simple negligence and gross negligence are quite different standards and do lead to sort of a change in the equation if something goes wrong and the burner and the harmed party are trying to figure out who should have to pay for the damage. So a simple negligence framework in most states really tries to establish a fictional reasonable person. So if you're in a court case and you're trying to figure out was the burner liable, the first thing that the two parties would argue about is what a reasonable person of ordinary prudence would do if they were in similar circumstances and they desired to comply with the law. So you'd be looking at what it would have been the reasonable thing to have done in this particular prescribed fire. How frequently should you have checked the weather? How much, due diligence should you have done about the particular site and the particular characteristics? How much contingency backup should you have had? How long did you need to stay on the site after the fire was presumed to be extinguished? All of these questions as you try to build up this sort of fictional person as to what was reasonable under the circumstance. This requires a lot of evidence. As you can see, it requires a lot of comparison to what other people in the community acting under similar circumstances would have done. It requires a lot of experts to come and testify in court. It's quite an intensive process to come up with that reasonable person. And then what you do is you take that reasonable person and you compare the activities of the burner to that fictional reasonable person. And as you can see here, if the burner did what a reasonable person might have done under the circumstances, then that person is not liable for the harm that they have caused. And so it's this two-part exercise. You create the reasonable person and you do the comparison. This is an incredibly fact-dependent exercise, which means that litigation under a simple negligence standard is very time-intensive, very expensive, and creates some interesting incentives for settlement, which I'll talk about in a second once I talk about gross negligence. So that's the standard for simple negligence. Gross negligence, on the other hand, really just looks at the activities of the burner themselves and tries to say the ways in which that person showed a degree of care, common sense, due diligence. So you're looking at the activities of the burner, and if that person has exercised a degree of common sense or diligence, then they are not liable for the harms that they have caused. And so instead of having to do this kind of two-part test of like define the reasonable person and do the comparison, you're really just looking at the activities of the burner and trying to show, did they exercise some level of due care? It is supposed to be a really lenient standard, meaning that if you've really done anything to help ameliorate the situation, mitigate for potential risk, then you should be cleared of liability in this context. It is very hard for a party that is harmed to prove that a person was acting with gross negligence. And particularly if you're doing the kind of prescribed fire that I imagine you all talk about, burn plans, permits, contingency resources, etc. You're going to have a lot of things to point to show how you tried to make sure that the burn was going to stay safe. The reason why this matters, again, in the settlement context is, so if you are thinking about, you've had a fire, there's been an escape, and let's say you've caused $250,000 in damage. You burned down a relatively modest house. There will be a question, and kind of you can almost chart this out about whether it makes sense for the homeowner to turn around and sue the prescribed fire practitioner or not. And the the reason why it may not make sense is because of the cost of litigation. So it's very expensive to sue someone, especially expensive to sue someone under a simple negligence standard, where you're going to have to prove all of this stuff. It's going to be expensive for the burner to defend that. And so a simple negligence standard, what it does is it really encourages settlement, because the cost of litigation is so high. It means that a burner, even if they think they might ultimately win that case under a simple negligence standard, they're going to have to spend so much in order to defend that they're like, well, you know, the house is worth 250. It's going to cost me 150 to defend this lawsuit or more. And so I'm willing to settle for, you know, $125,000, even if I think I did nothing wrong and I could ultimately prevail. Under a gross negligence standard, because the cost of litigation is relatively low, and because the homeowner, the damaged party, has such a lower percent chance of succeeding, that calculus is going to be different. And so it's much less likely that you're going to see these situations where a burner is incentivized to settle for a really high amount. And so that's some of the differences between simple negligence and gross negligence, and why folks in the sort of legal and prescribed fire advocacy community have been talking so much about these two distinct differences. Okay.
Sarah, can I ask a question real quick?
Yeah, sure.
The gross negligence piece for Georgia and Florida, do those two states have a claims fund, or do they not have a claims fund?
They do not have a claims fund. And they have had, what they have is certified burn manager or certified burner programs that go hand in hand with their gross negligence standard. We'll talk about this a little bit more, but one of the things that I think is really interesting is this means that if there's an escape, it really means that the homeowner is going to be on the hook, or the damaged party. Like, there's not somewhere else they can turn to. My understanding is that in general, the homeowners and property insurance markets have been pretty reasonable for a while in Georgia and Florida, especially when they first passed their laws. We're seeing an insurance crisis across the board. And so I think there's going to be some interesting questions for both Georgia and Florida moving forward as to whether the state continues to feel comfortable putting that risk of loss on the homeowners. Does that answer the question?
Thank you, appreciate that.
And I've got a question on this topic as well.
Yeah.
So we were hearing from Montana at the moment working on their simple negligence standard as a step toward, it's their Honda Civic toward their, working toward their Cadillac of gross negligence.
Yes.
I'm curious, from a state agency perspective, what's the risk of going with a gross negligence? Like, what's the concern that people have with going with that negligence standard from a state agency, from a fire protection agency standpoint? And also, do you know if there are states that have then adopted a gross negligence standard that have not regretted it, but just like, has there been some negative outcome because of something coming down the pipe with people having that?
Yeah, so I think the two arguments against a gross negligence standard are, first, what we always hear is, and especially from agency folks, is like that a gross negligence standard creates a disincentive for people to be careful. That effectively, because like it's very, like if you just try a little bit, you're not going to be liable for third-party harms, that means that for some reason they think people are going to go around to just like light whatever they want on fire, and like, you know, it's going to disincentivize the kind of level of rigor and due diligence. What I like to say is, like, even if you're not going to be liable in a court of law at the end of the day, I think most prescribed fire practitioners would be pretty upset if they had a burn get away from them and they caused damage to their community. And so, like, I think there is still sufficient incentive for people to not want to have that kind of harm occur. But that is the first argument against a gross negligence standard. The one that I find more persuasive, the sort of second argument, is that under a gross negligence standard, it means that you are effectively leaving third parties that had no choice or involvement in the matter, kind of holding the bag for the rare escape. Right? If you burn down your neighbor's home, they didn't have a choice as to whether you set the prescribed fire, they weren't involved. And if there's a gross negligence standard, that means they really are going to be unsuccessful in suing you and having your insurance or your assets cover their loss. And so there's a bit of an equity question there as to who should bear the risk of that rare escaped prescribed fire. And I personally find that one to be a little bit more persuasive. We have not seen in kind of the empirical data any evidence that a simple negligence versus a gross negligence standard leads to a difference in outcomes, meaning it's not as though in Georgia and Florida, we're seeing a lot more burns escape or people being less safe. And that's in part because there's a lot of other structures in place to encourage safety. So I don't think that there's any states that have kind of quote regretted going to a gross negligence standard, but I do think you tend to get pushback again from that kind of equity perspective.
So just to summarize, for myself. Gross negligence will make it less likely for people to engage in litigation, but may not be as equitable if it's not accompanied by something like a claims fund that would
Exactly.
support
Compensate them differently.
that would compensate them.
Yeah.
Because instead of looking for compensation from liability, they wouldn't be getting compensation from a liability action. They would be getting compensation from a claims fund. So that could be both beneficial for reducing litigation and also equitable by providing some means to provide loss coverage.
Yes, that's exactly right, Heather. Yay! Good.
Thank you.
Yeah, of course. Okay, moving along, and this one I'll do for fairly briefly. So I do want to talk a little bit about what's called the cause of action. So we have talked about kind of the things you could be liable for and the standards that would apply. But if there's actual litigation brought, there's a couple of different theories that people could bring those claims under. And this is more so you just have familiarity around these topics. And because when we start to talk about what is in Idaho's law, these words will come up. So nuisance is the idea that a individual cannot do things that creates a nuisance or harm to other people. And so like a kind of prototypical example is like a factory operator that is, you know, let's say they're crushing rock and they're causing vibrations in the community and they're causing dust in the community. Those vibrations and dust are general, they're at a relatively low level, but they are kind of creating these externalities from their activity. In common law, which is a phrase that we use to refer to kind of a suite of laws that don't necessarily need to be codified and passed by the legislature, but are instead created by the courts. A nuisance action is one way that a prescribed fire might be a cause of action that might be associated with an escaped prescribed fire, meaning that if you have an escaped prescribed fire, it turns into a wildfire. You're kind of creating these nuisances to the community at large, and the burner might be liable under a nuisance cause of action. And similarly, or relatedly, the other kind of common law cause of action is for trespass. So common, like the basic definition of trespass is like you know, you have adjoining property owners, and one property owner is like, oh, I wasn't quite sure where the boundary of my property was, and I went over and I cut down these trees and then I sold them. They will have created a physical trespass onto the other person's property. They have gotten monetary gain out of that by selling the trees, and the one property owner could sue the other for a trespass cause of action. You can also have trespass from fire. So having a fire that you create go onto someone else's land can be trespass. Similarly, smoke from a prescribed fire that goes someplace unexpectedly can be a trespass cause of action. Like in order to prove nuisance or trespass, under state law, you tend to go back to the applicable negligence, strict liability standards that are at play. But I just wanted you to know that those words, nuisance and trespass, come up. I know you've had some conversation. I know it's come up in other contexts before. So those are the two different ones that are at common law. States can also create what's called a statutory cause of action. And you could have a state law that says, like, for instance, you know, there can be a civil action by a party harmed by a prescribed fire against a burn boss or against a landowner if they fail to comply with X, Y, or Z standard. So this is a way in which the legislature and advocates can go about changing what the standards and causes of action are for an escaped prescribed fire. And so just know that nuisance and trespass are sort of what operate in the background in the absence of the legislature coming in and taking specific action. But then you can add these statutory causes of action that either modify or build on those background causes of action to change things in a way that either makes it more favorable or less favorable for prescribed fire to happen within a state. So that was really the mini little law school activity there. Again, you don't need to really take any of that, and I'm not going to test you on it, but I just wanted you to have those words nuisance and trespass sort of in your lexicon. Okay, let me just pause there and see if there are any other general questions, and then I can get into a little bit about what I am seeing specifically in Idaho's law.
Any questions? Everyone's completely clear. They're ready for their degrees in law.
Okay, great, perfect. I will be, we'll do a diploma ceremony at the end. First, you have to take a test, but
No big deal.
no big deal, exactly. Just the prescribed fire bar. It's very, very, very
Man,
subjective.
that's an idea. Good. Maybe I'd study better.
Exactly. Okay, so if no questions, then I'll move into what I'm seeing in Idaho specific laws. And I will say I find your law to be not entirely clear, and having reviewed what other folks have said, I guess I'm glad to say I'm not not alone in that regard. But I think there are kind of three main pieces of it with respect to liability that I wanted to highlight for you. So first off, I think your standard for suppression costs is pretty darn clear. And this language comes in 38-1071, which I'll read it out loud. The director of the Department of Lands or any fire warden may summarily abate the nuisance constituted by the prescribed fire, and the person willfully or negligently responsible for the starting or existence of such fire shall be liable for the cost incurred by the state or its authorized agencies in controlling or extinguishing the same. And so what you'll see here is you have this willful or negligently responsible language. So this is a simple negligence standard. I'll first articulate what willfully means. Willfully is like one step beyond negligence. It's basically like if you're doing something basically on purpose, that doesn't quite constitute arson, but nevertheless, if you have that, if the state could show that you were trying to have the fire escape, then that would be willful. But negligent is that negligence standard, that simple negligence standard. So here we see that in Idaho for suppression cost liability, you have that simple negligence standard. It is pretty clear. And it is pretty broad. It's any costs incurred by the state in controlling or extinguishing the same. The one thing that I don't see called out in particular is investigation costs. In California, we have a very specific provision that the state can also cover for investigation costs that arise out of the potential escape. I don't see that, but I haven't studied your case law to see if that's been attempted or tried, or as a matter of administrative policy has been pursued.
As a matter of administrative policy, we do not seek investigative costs.
There you go. Thank you, Archie. Glad to have that answer. Look at that. Okay. So then we have this mention, and this comes in 38-107 too. And this section in general is talking about what particular types of damages are recoverable. And I'll talk about that in a second. But what is interesting in here is it mentions the potential for a civil action against any person, legal entity, state, or political subdivision for a forest or range fire caused by a negligent or unintentional act, which act was not willful or intentional. So what that says to me is that this indicates that there is the potential for a civil action, meaning a lawsuit, for a forest fire that was caused by, or range fire that was caused by a negligent act, which is what we talked about, or a forest or range fire that was caused by an unintentional act. So negligence gets to that state of diligence, whether or not you have shown due care in taking the proper precautions and mitigations during your planning. Unintentional gets to a question around underlying intent and whether you intended for the fire to escape or not. In most instances, prescribed fire practitioners are not intending for their fires to escape and could cause a forest or range fire. So what I am concerned about is that this creates a little open door that there could be a civil action simply because you did not intend for a forest or range fire to be caused by the prescribed fire. And so this is where I see a little bit of lack of clarity in Idaho's law as to whether you are in a simple negligence framework or potentially a strict liability framework, which, as we talked about, is the place you don't really want to be. I'm not aware of any case law that has explored the meaning of this by the legislature. I haven't looked to see whether there was any legislative history, basically like discussion in your legislative body is about what the intent of this language was. But I did just want to flag that this is a place where you could look to get some more clarity and really try and figure out, can we at the very least make it very clear that we are operating under a simple negligence standard rather than creating an open door for someone to argue that this is a strict liability state. The last thing that the code does that I just wanted to flag is we do have some nice limitations on cost recovery by third parties. So we talked about that bucket of third-party damages, and in most instances, they're like anything that the harmed party can prove is potentially something that the burner is liable for. So you burn down the house, the cost of the house, replacing it, that can be liable for. But what about like business cost? Like if you're running a business out of that house, or you burned down a business, like what about the profits that business could have been making during the period? What about the emotional, infliction of emotional distress that you've caused by creating an escaped prescribed fire? What about potential health impacts from prescribed fire smoke, either that might happen now or in the future? There's a lot that can be in that third-party damages claim, and here you have some limitations that the state has laid out for what costs can be recovered. And in particular, it is suppression costs, economic damages, and the economic damages has a long paragraph that kind of articulates specifically what those mean, but the general category is objective, verifiable monetary loss, and then the third category is either a diminution in the fair market value of the property or the restoration costs of restoring the property. What this leaves out is the potential for punitive damages, natural resource damages, some potential health and emotional distress damages. So it does create, it kind of cabins the potential scope of exposure in a potential lawsuit related to an escaped prescribed fire in a way that I think is helpful and is another place that you could consider even doing more to. One of the things that we've been arguing for, haven't had it passed yet in any context, but are trying to articulate the case for, is that in California, we've seen some cases where there's been an escaped prescribed fire, it's burned through adjacent forest land, and then the adjacent landowner has tried to claim not only harm to timber, but also like harm to natural resource damages and like an associated sort of economic value of those ecosystem services that the landscape provided. And what has been frustrating is that in some of these cases, the forest land that burned looks great. Like it ended up being like, we should just count these as more acres treated because the fire didn't burn at very high intensity and we didn't have, crown fire effects and that sort of thing. And so I personally think there's like also some limitations around recovery for fires that are actually doing good for the landscape. So another potential option there. So that's what I'm seeing in Idaho law. As I said, I am not, I don't practice in Idaho, and so there's probably nuances here that I haven't gleaned, but wanted to pause there and see if there are any questions about that, and other folks in the room that have different views or other specific information.
Questions? I got some too. Go ahead, Matthew.
I want you to go first, because I was gonna actually drag DEQ into my question, so.
Okay, mine, well, we'll see. Yeah. I'm wondering, I know that words, like little teeny words, are sometimes pretty important here, so I, like, at some point, we're gonna look at the words that we have, and we're gonna make some potentially some proposals on language changes. Some of the advice that I've been given from John Weiss from Oklahoma is like, just be really careful when you're going into this, any type of legislation change. First of all, his counsel has been kind of resolving whatever kind of liability concerns you have isn't a magic bullet to make
Yes.
prescribed fire like all of a sudden more accessible. So don't get your hopes up. As soon as you remove that barrier, you'll see the other ones that were actually there that you need to take action on. And the other thing he said is when you open up the can of worms for liability, language changes or legislation language changes, stuff happens when you are in that process of getting things approved. So all of those I'm keeping in mind as well. But I wonder if within these particular statements that you pulled out, like what would happen if the simple act were, and I say simple here, if you took out the word willful and you took out the word unintentional, like if it just was person must be negligently responsible or fire caused by negligent act instead of unintentional, is that powerful enough that it would be clearer about what its purpose was?
Yeah, so first off, totally agree with that advice. And we can talk more about what has happened in California, but it's like once you open this box, other people want to play in the box too. And sometimes changes happen to what you're proposing that you're like, no, oh, okay, that's not what we wanted to happen. So I appreciate that advice for sure. However, I do think for me, striking or unintentional could be immensely helpful. Right now, I think that word is giving me a great deal of heartburn and could give you some real ammunition to say that you have a strict liability standard in Idaho. I don't think you need to strike willfully. Willfully is kind of a higher bar. It's easier to prove that someone was willful, and it is not likely to be happening for you and the folks in this room. It's really a piece of language in there intended to ensure that if there's arson or arson-like activities, that the state can get their suppression cost recovery. And so I think if you were to try and strike that, you'd have some pretty immediate and warranted pushback. So I would keep in willful, but I would omit unintentional.
And willful, we're talking about willful of ignition outside of the intended area. So
yeah,
outside
exactly.
Right. Okay. So I'm willfully lighting this,
No.
but I'm not willing to light that.
Yeah.
So this is talking about whatever would be outside of my intended area.
Yeah,
because
exactly.
Again, get to the question. I know that we're looking at the state of Idaho's, so let's say IDL is asked to burn on private property or whatever, someone else's property. They are willfully lighting that area intentionally.
Yeah. And you could provide, looking back at this exact language, you could provide more clarity that the willful there really should be applying to, you're not willfully causing the escape. You're willfully starting the fire, but you're not willfully causing it to get out of control. And so there could be some language clarity in that regard as well.
Malicious intent. Yeah. So
yeah, it's really a malicious intent. That is what it's getting at. Yeah.
Okay.
So I know I looked into this with the city of Boise, and those two statements, the willful and negligent responsible, and then the unintentional act, are the two main reasons we're not even remotely close to doing prescribed fire in the city of Boise. They said those two statements right there leave us so wide open to so many lawsuits for who knows what, that it wasn't worth the city's time the way it was currently written.
Yeah, I can see why, as I said, heartburn here about that particular language.
Matthew?
DEQ. My question is about the CRB program, crop residue burning program. And my understanding is there was at least a threat of litigation from ag burning in North Idaho that instituted the CRB program. If that's true, was it related to this negligent, unintentional, or this nuisance smoke that's in the statute, Idaho statute?
There was a lawsuit, and it wasn't against TQ, it was against the SIP, for the state, and I was not with them, this was back in 2000.
Which Mary was on.
I know,
She
she's like, I got this down. So back in 2007, there was a lawsuit, it was brought against us by, I think Safe Air for Everyone was who brought it against, and it was a smoke. I don't know if it was the negligent or where it came from, but there was a death. All burning was shut down for 2007 until DEQ got the program in 2008.
So there was a death attributed to the smoke?
Was that from the Rathdrum
Yes.
Prairie burning?
It wasn't that after the Department of Ag
Department of Ag has their program.
had the program,
Mhm.
and then they didn't have the program. And it was taken out of our SIP, right?
Yeah, there was a piece that was, and so, yeah, something to do with, it wasn't in the SIP.
Our state implementation plan with the EPA that says, we're going to make sure crop residue burning doesn't cause a problem, et cetera. Like, we have to have all these pieces in our SIP. And for whatever reason, crop residue used to be in it, because it was taken, because it was part of the Department of Ag, so that's how it's gonna be taken care of. But then Department of Ag didn't want it anymore, or legislature said, we don't need to do this. There was something to do with that. We took it out of our SIP because it wasn't being regulated in that way.
And we as an.
Yeah,
No,
not to
Yeah.
Then this problem happened. Death was caused. Then we got sued because, oh, that should have been in your SIP.
So then is the forestry related burning in the SIP? And it has
Yeah.
always been in the SIP and
Always.
always been under DEQ?
Yes.
Okay, now I'm getting a lot more clarity, thank you. I don't know, Sarah, I just needed to bring that up, just because as the Nature Conservancy, we have crop residue burning, and I've always been confused about the differences in the regulations between crop residue burning versus the forest practices, that type of stuff.
Yeah. and
Yeah.
the Ag was taken out, then ag was put back in, because once it was taken out, you couldn't burn. Like, because our rules say you can't burn unless it's an allowable form, and so once it was taken out, like, the words were removed, it's an allowable form, then you can't burn at all.
Okay, so that's really where the lawsuit was hinging on,
Yeah.
it was kind of an unallowable because it wasn't included, which is a little bit different than what we're talking about here.
Yeah, exactly. That's a lawsuit aimed at the government in its regulatory capacity. The lawsuits I'm talking about here are really lawsuits between private parties, civil actions between two private individuals for loss or damage caused to one of those individuals. And so it's a little bit different. They do interact. This gets into like the 201 class, but like compliance with your permit conditions or regulatory environment can be one of the ways that you can prove or disprove simple negligence or gross negligence. So there is an interaction between the regulatory environment and the civil liability structures that we've been talking about, but it sounds like this particular example was more of a action against the government. But just so like on a brief aside, because it's one of the weirdest things that I've seen come out of the new administration, and potentially good, is just a note that that one of the deregulatory actions that was in the list of 31 actions that EPA took last week was actually a proposed modification to the exceptional events rule to really direct states to encourage greater use of all forms of prescribed fire in their SIPs. And so just as a heads, like that rulemaking, this was just on the list of like a to-do list for the Trump administration. And it would have to go through a whole rulemaking process, but just wanted to note, given that you're talking about SIPs, that came up last week in a kind of unexpected and a little bit strange way, so.
So this, what we're talking about here is like an individual person, landowner, burning on their land. And if something goes out of the intentional area, if someone is injured, they have you could have them sign a liability waiver form. If you damage property outside of that area, you, based on whatever state policy we're looking at here, or might have in some future, if we're in a gross negligence state, let's say we set things up and we have a gross negligence state and we have a claims fund and fire gets out of your intended area, does third-party damages, you aren't sued and the claims fund covers the costs. The claims fund could also theoretically cover the cost of suppression action that's taken place, and it pays the state agency or whoever fire response district for their time. That could additionally come out of the claims fund. So this to me is like private landowner burning. I own the land, I'm burning the land, it went out of my box and it caused these costs. What is continually then coming up is, could you burn for me? Like the number of emails that I get, like, hey, I hear you're burning people's stuff. Could you burn my stuff? That'd be great. And then I send them like the liability waiver forms and they're like, never mind. And this is challenging both within our state agencies' policies about how they view their responsibility for the use of fire versus fire is ultimately always a bad thing and needs to be put out. And so I'm not sure. I guess maybe let's start with one question of this idea of someone else burning on somebody else's land.
Yeah.
So let's say I'm an individual person burning on an individual person's land.
Yeah.
What are some thoughts you have about liability there?
Yeah, so really good set of questions, and there's a lot of complexity here, but I'll try to keep it simple. When a burn gets out of control, the party that is harmed is going to look to sort of everyone that was involved in that burn. So in the example you gave, they will likely sue both the landowner and the person they've hired or contracted for to come. As well as like if there was anyone that was volunteering or there was a funder liability is sometimes an open question. I think that's a harder case, but certainly questions around that come up as well. And so all of the things that I talked about would apply. The same analysis would apply to all the people involved. It may be that some of the people really had no causation to the burn, right? Like a volunteer that is there and just followed directions and didn't do anything wrong may not have caused the harm. And so there will be no liability for them. A burn boss, on the other hand, might be the reason why the burn got out of control, or the person that was supposed to check the weather and didn't, or the person that was supposed to stay and monitor for, whether or not the fire was fully out, they fell asleep, something like that. You have to look at first, like what the underlying cause is, and then whether the people that potentially caused it were negligent in their actions. But it's the same framework. You just look at sort of everyone across that's in that potential portfolio of defendants.
So something that's coming up also regularly is so last week or 2 weeks ago, we had the Idaho Youth Ranch emailed me. They're like, hey, we've got this acreage. We'd love to get it burned. Could you burn that this spring? Or something like something more immediate. And like, so then sometimes there's this instance of like, who is the landowner?
Yeah.
And and so I see this who is the landowner coming up in like land trusts or county land or city land, or like ultimately like what I've generated for the University of Idaho is this liability waiver form with the help of our attorneys. And it essentially says the landowner will sign it, and they say that the landowner takes responsibility for the actions of the outcomes of the burn, and they indemnify anyone from that's helping with the burn,
Yeah.
essentially.
Yeah.
But how would you even approach, and are there examples of this in California? I'm sure that there's similarly confusing ownerships in some of these instances, like who signs the liability waiver form and then thereby absorbing the liability from said action?
Yeah. So there are two different pieces I want to pull on here. So first on like who should sign as landowner, it should be the person that has fee title or ownership or control of that land. And so you're going to have to figure out like who is ultimately on title for that particular property that you're burning on. The places that gets confusing is like if you have a ranch manager or an operator, etc. Then you might need to understand a little bit more. Well, what's the relationship between you and your landowner? Do you have authority to sign on their behalf? Those are some of the questions that I would ask. You bring up indemnification, and this is a really important part because when you get into these situations where it's not just like, I own this land and I am doing the burn and no one else is involved. Indemnifications are the mechanisms for allocating risk between all the participants. And they're not foolproof because they're only as good as the assets or insurance of the person who's indemnifying. But their intent is to say, this person is sort of the first in line as defense, the person that is the indemnifier. And that means that if there's something that goes wrong and there's a lawsuit, the indemnifier steps up and is like, I will defend this lawsuit. I will pay all costs if we're ultimately liable. And everyone else that was there on that day sort of can go home and wait and hope that like at the end of the day, either I defend successfully or that I have enough assets to cover any losses. There are lots of questions when you're burning in cooperative arrangements as to who should hold that indemnification responsibility, like who should be first in line. And I'll say in California, I work with a lot of groups and they all handle it or choose to handle it in different ways. Some will say it's always the landowner's responsibility. Some will say it's always the burn boss responsibility because they're the ones that are the most in control. I will say with public entities and universities and other sort of big institutional folks, they always want someone else to be responsible and their lawyers will almost never allow those entities to be the indemnifier. So indemnification is a way for allocating risk between all of the different parties that are actively participating in the burn, meaning the landowner, the burn boss, volunteers, funders, etc.
Got it.
And you can do that sort of irrespective of what the state law says. That's a contractual arrangement between the parties, so long as you're complying with the requirements under Idaho law for what indemnification language and kind of what the magic language is.
Matthew? So then this question that I have about our state agency. So there's stuff within our state agency, and this might be honestly a question for Archie if you're still on. There's just a couple of things within our state agency. I don't know enough to know if this is state policy, is this IDL policy that are going to make it hard to move forward with prescribed fire. Namely, well, first of all, within the state agency itself, I know that there's a total network of connection of why it's challenging to have state employees get overtime for doing prescribed fire as a policy. But then it's just in general, the view that the agency has about fire. And I don't know, Sarah, if you've looked into like what, how other states have set their, like right now, it feels like the use of fire is against the mission statement of IDL, and that's going to be kind of an opposing line until that gets adjusted. I don't know. Any thoughts there?
Well, I want Archie to go first if he has thoughts before I opine on an agency I'm not familiar with.
Thank you, Sarah. I think first, I don't want it to sound like that as an agency we're opposed to prescribed fire. We're not. We would love to be using it more on our own lands where it was appropriate. But for many of the things that Sarah just went through, it just makes us so nervous at this point. We are working to try to get more clarity on having the ability for IDL employees to work on private lands, to do prescribed fire. We're working on trying to make it possible for our employees to get overtime when they're working on prescribed fire. And, back to the liability questions we were just talking about there with the indemnification, the state of Idaho, under statute, cannot indemnify anybody. So we run into that all the time. We'll do contracts between states, and the two states are like, well, you have to indemnify us. And it's like, but we're not allowed to. You have to indemnify us, but we're not allowed to. So we found ways around that through our attorneys, but the state is not allowed under statute to indemnify anybody for anything, which Sarah's probably familiar with. I see her nodding there.
Yeah.
So that trips us up on a lot of agreements, actually. We even run into that with the federal government, who also cannot indemnify anybody. And yet they'll look at you and go, but you have to. Well, how come you don't then? So anyway, so indemnification is a thing, and then, again, it goes back to the liability side of it, and putting taxpayers under the liability for escape. We've been looking at these laws. We've actually paid for a study of the laws and across the country, and we just recently got results back and sent some more questions in, and so that's ongoing. But we're trying to get to a place where we can participate more actively in prescribed fire, in applying prescribed fire in some of our other hazardous fuels treatments. I mean, it's one thing to go out there and do the basic treatment, but if you don't follow it up, don't keep it going, did it really do as much good as it could have? So we're trying. I guess it's a terrible answer, but that's the best I can do.
Oh, it's better than many answers.
Yeah.
Yeah. I'm happy with that answer.
I would add just a couple of things on that, and totally appreciate all of that, Archie. And I definitely have seen flavors of that across the West. First off, there is an aspect of state and federal law in most states, and I actually don't know the specifics on it in Idaho, but called tort claims acts, which are essentially shields for the ability of private entities to sue the state and federal governments, except under specific circumstances. And so one of the ways that can help, and it's another place you can kind of think about making modifications to, is essentially the state can create using its sovereignty, create a way in which individuals can't sue the state for harms that they cause. And so individual employees are still often very afraid that the Tort Claims Act coverage is not sufficient and that they still might be personally liable. There are ways of addressing that as well. But Tort Claims Act coverage, and making sure it's very clear that it is available for prescribed fire, it might be a potential way of creating some additional clarity for state employees and local employees engaged in this work. The way that the federal government has kind of used that to help in this context is they won't indemnify, but they have created structures in which folks burning on federal lands actually can be kind of under the Tort Claims Act shield. And so they, if you're a nonprofit organization that's operating under a master stewardship agreement, you can get Federal Tort Claims Act coverage for your employees because you're effectively working on behalf of the government. And that creates a shield against these kinds of lawsuits that we were talking about. And so that's another potential place to look at and tweak and potentially modify. The last thing on the culture piece is I'll just offer my view as to CAL FIRE over the last 8 years. I would say when I first started working in this space in California, CAL FIRE was, it's one of the largest suppression agencies in the world, and they view themselves as the best at suppression, and they were not super excited about prescribed fire. But I will say now, having engaged in particular on the claims fund stakeholder group, which was led and directed by CAL FIRE, it's been amazing how much the agency has really changed over the course of 8 years. And I think a big part of that has been they've hired some folks that have a real interest and expertise in prescribed fire. And it is always amazing to me how much like 1 or 2 people in key positions can really make a difference. And so I would say that is really important. The other thing that happened is just this past year, this is relating to the overtime thing. Some CAL FIRE employees like worked with the prescribed fire community and said, you know, the reason we can't show up on your burns is because of this overtime act and because of some of the other kind of procurement and state administrative burdens that make it really hard for us to deploy people to prescribe fire. We would love if it was treated more like suppression activities, where it's very easy for us to do procurement and overtime and all of the like direction of assets. And so we worked with some actually ex-CAL FIRE folks and wrote a bill, SB 1101. No, I'll find the exact number and I'll send it to you if you're interested. But what it did is it says for CAL FIRE, they can use all the same procurement, overtime, administrative requisition, other kind of inside rules that they use for suppression for prescribed fire, and really tried to eliminate those bureaucratic hurdles that were preventing state employees from showing up for the prescribed fire community and from being able to do burns in sort of a flexible and you know, the weather window is right, let's be able to show up kind of approach. So it's only been in effect for 3 months, 2 months. So I'm not quite sure how it's working yet, but that was the idea. And so that's another thing you could potentially look to mimic in Idaho.
Awesome. Thank you.
I would love to see that.
There is
Yeah, I'll find it.
haven't been in, you know, the fire program here for those 20 years now. When I first started in 2005, like Ron Blitz, you probably remember Ron, right? Winston Wiggins, I mean, any fire that was not lightning caused was to be investigated, and if you could identify the responsible party, they were billed. So it didn't matter if, you know, grandma was out doing whatever and had a bad day and the wind blew and her fire got away and, you know, she didn't have, you know, 2 nickels to rub together, you would send her a bill. But in addition, you know, if somebody was out making piles and, you know, trying to do the right thing by cleaning up their property and the fire got away, they would get a bill. Any kind of like holdover landing pile or any fire at all that was human cause would get a bill. You know, over time, we've kind of, you know, culturally, we've kind of like, okay, you know, we've kind of, and Archie can kind of speak to this too as being one of our primary investigators, but there's some that, you know, are not as aggressive as we were 20 years ago, but we're still pretty aggressive. I mean, there's definitely a cultural shift, but there is also that legal hurdle that we still haven't totally figured out. And Archie, as an investigator, like when I was a warden, I would give a recommendation, like, you know, let's try not to bill this one, and we still have the responsibility to investigate it. And I would leave it to those guys to decide whether they're actually gonna, you know, be the bad guy and send the person a bill. But I mean, you know, if you want to encourage a practice, if we want to get more stuff done out on the landscape, it's a pretty big disincentive to send somebody a bill every time the wind blows. And we don't want to discourage people from calling us and asking for help if they know that we're going to send them a bill for that. So yeah, we'd rather give help and not penalize them for trying to do the right thing.
Yeah.
Yeah,
Well,
we do have.
Jessica, oh, good, Archie.
We do have some flexibility there. It's relatively limited, but it goes back to, you know, what Sarah was talking about with the negligence. Was it a negligent act? You know, should they have known better? And so we, you know, there have been fires that we didn't bill for, but you know, if you dump your charcoal grill out on your neighbor's property, yeah, you're going to get a bill. You know, if you know, you're burning leaves and you know, you had a bucket of water, you put it out, you stirred it, you thought it was out. that's debatable. We'll have to have that discussion, so. And then, of course, anything willful, you're definitely gonna get a bill, so.
Well, we have Jessica, I'm like pushing you guys today with we have like attorney time for just this brief period of time, so we're just gonna power through to get through the important stuff. We do have Jessica Gunder on to, share a little bit with us, and then we'll have a little bit more time for some follow-up questions, after that. So if that's all right, I'll switch over to you, Jessica.
Sure, yeah. Is the audio okay? Can you guys hear fine? I see, more or less nodding. Okay, I'm gonna go ahead and share my screen then. So, good afternoon. Hopefully you've had breaks and things that I haven't seen, and whatnot. All right, it is lovely to join you this afternoon. A little bit about me. I'm an attorney, as Heather noted. I worked for about a decade for the federal government in various roles. Including spending time at the Department of Justice out of Washington, D.C., and then here in Idaho as an assistant U.S. attorney. I then joined the faculty at the University of Idaho's College of Law in 2017, and I teach a wide range of courses here at the college. I'm here today because I received a grant from Idaho Department of Lands to look at some programs that other states have employed to increase the use of prescribed fire. And we're going to discuss some of my findings along with the other topics that you see on this slide. So starting with what is the law in Idaho, although I came in a little bit in Sarah's presentation, and based on that slide, I'm guessing that you got a decent overview on this. Heather, can you let me know if I should just keep moving?
I think we covered this pretty well. So I think you could keep on going.
That sounds perfect. Okay, so Idaho law, y'all are experts. Perfect. So turning then to what other states are doing and what we're seeing, and what kind of I was looking into as far as ways to increase the use of prescribed fire. So I really primarily looked at two different kinds of programs. The first is states that have created indemnity funds and pool insurance programs, and specifically looking at the 3 states that you see here. So California is the first one on the list. These are really just alphabetical. California's program is a new one. It's a pilot. They've termed a pilot program. It was signed into law in 2022 and launched in 2023. It had 2 goals, right, for this pilot program. The first was to increase the use of beneficial fire by removing an obstacle, right? And then the second was to try to demonstrate that this is a low risk practice in order to try to bring some insurance companies back into the market. So the pilot program is relatively new and it expires in 2028. So they've got kind of a window where they're giving this thing a try. Essentially, how their program works is that prescribed fires that meet the eligibility requirements for the fund are eligible for up to $2 million of coverage. There is a limit. They can only have 200 burns enrolled in this program in a year. And so people who are planning burns, they will enroll theirs and then they get that protection. The fund is a little bit limited in sort of what damages it'll cover. For example, it'll only cover damages that occur outside of the planned burn unit. It's intended to cover property damage, personal injury, and death. It will cover smoke damage to real property, but not damages or physical injuries that result from like a vehicle accident that's caused by smoke, or smoke related and fire health related claims like asthma or exposure to toxic fumes or things like that. This is obviously still very early days for this program, but it seems to be working well. The first year had 99 burns that were enrolled in the program. 2 of them exceeded their boundaries slightly, but didn't cause any real damage, and no claims ended up being made against the fund. And as far as like those 2 goals that I mentioned at the outset, they've already accomplished one of them because a private insurance company has re-entered the market in California. So is looking fairly positive for what that's doing. The second program I looked at was Georgia. Georgia doesn't have a statewide program offering liability insurance or an indemnity insurance fund. They have had legislative advocacy to try to get one, but obviously it's a kind of fiscally conservative state and that hasn't gotten a lot of traction. But As an alternative, what's happened there is that 3 different prescribed burn associations have kind of taken matters into their own hands and have tried to offer a solution for their members. So these three PBAs launched a program. It just started in November 2024, and they've created a risk pool insurance policy for their members, which total about 1,300 landowners in those associations and counties that are affected. And so it is a private program, but it is being supported by Georgia's Department of Natural Resources. And how they've finessed this is the Georgia DNR is providing the funding for the first year of the program. And they're doing that through revenue that they've received from their license plate tags. And then the plan is next year that the PBAs will cover half of the cost of the policy, and Georgia DNR will cover the other half. And then for the 3rd year, the PBAs will pick up the full cost and hopefully go forward with it. They are hoping that the insurance policy cost drops over this time frame as the insurer realizes and recognizes kind of the level of risk involved, but that's what they're doing. This is obviously so new, kind of premature to assess whether or not it's actually successful. But they modeled this off of a program that was, off to a good start in Alabama. And so they're kind of hoping for some similar results here in Georgia. All right, 3rd one on my list, Oklahoma. Oklahoma to me is such a disappointment, but that's, my own opinion. So Oklahoma passed legislation creating a controlled burn indemnity fund in 2007. I was asked to look into it, and what I found is that it never actually got off the ground. So they have never funded it, and it's almost 2 decades later, right? So while this thing exists under Georgia law, they've never allocated any funding to it. It's not actually available to burners in that state. All right, so then in addition to indemnity funds and pool insurance policies, the other kind of programs and category of things that I looked into was kind of a series of states that provide some form of liability protection in exchange for completing training. And so you can see the states listed here, again, not in any order other than alphabetical. So I'm not playing favorites, I promise. They are generally very similar. There's a lot of similarities between these programs. Essentially, you complete a course. You usually have to do some training burns and certifying burns. They call them different things after the fact. And then you can be a certified burner in that state. And it means that then, so long as the burn you conduct follows certain requirements, like you get all your permits in order and things like that ahead of time, then you won't be liable for any damage caused unless you're grossly negligent, right? So it changes the liability standard to gross negligence in certain specific instances where you've had that training and whatnot. So let's chat a little bit about each of these programs. I won't belabor them too long, but some of them have some interesting nuances that I think are worth considering. So first on our list, California. The statute in California provides indemnity for costs related to suppressing the fire and investigating it and rescue costs. So it's really kind of something to think about, is that, like, how broad and expansive is that gross negligence standard? Is it providing protection for any resulting damage, or is it just kind of a niche area of damages? And that's what California has done, is provide relief and gross negligence standard for just kind of a niche area of damages that might result. I will say California's program is pretty rigorous, and more rigorous than most. It's got fairly significant prerequisites before you can even take the class, and then also requires 8 hours of continuing education every year that needs to be done in person. So then we've got Colorado. Colorado's program provides protections for any kind of damage that results from a prescribed burn, so long as the burner isn't grossly negligent. So it's much more broad than California as far as what scope of kinds of damages it's going to cover. Colorado's program started in 2015. Approximately 500 people have completed the classroom component of the course. But interestingly, most of those individuals haven't gone on to complete their required training burns. So only about 40 individuals have actually become certified burners in Colorado. Florida law was modified in the late 90s to have that gross negligence standard. So they've had gross negligence as their legal standard for a long time now. To qualify for it, the prescribed fire needs to meet certain requirements, including having a certified burn manager present during the fire. The class that they offer in Georgia is really in Florida is really popular. Every class they've offered this year has been full, right? So it's definitely something that the people in the state are interested in attending and doing. All right, Georgia. Georgia's gross negligence standard is unique. It is the only one that I looked at that it applies to people who have their certification through completing the class, but the gross negligence standard in Georgia also applies to individuals with previous prescribed burning experience. And so you don't actually need to go through the class and get your certification to be protected under Georgia's gross negligence standard. And that's the only state that I'm aware of that gives that protection to people that haven't done, specific training. So the standard itself, it's limiting liability for damages or injury caused by fire or resulting smoke unless gross negligence was involved. So kind of a broad protection encompassing fire and smoke. Georgia's program, similar to Florida, has been around for decades. It's very popular. As of last month, when I was talking with someone in their office, just over 6,000 people have completed the course, and approximately, of those, about 4,000 have gone on to complete their training burns and have the 2 years of experience they require to become fully certified. So, people are both taking the class and doing the rest of the work to get their full certification. Michigan. So Michigan, another one that makes me a little sad. So Michigan passed their statute in 2004 to limit liability for damages to conduct that's, so long as it's not grossly negligent. But despite the fact that the statute was enacted in 2004, they never allocated funding for a staff position or to create the training course or to do that work. So the course had never been offered. That is about to change though, so there's a little bit of light there in Michigan. The funding was allocated in 2024. The state has now hired someone to launch the program. They anticipate offering the course for the first time in October 2025. So that is coming. North Carolina then. North Carolina used to have a simple negligence standard and it changed really recently. So in 2023, it was changed to gross negligence. It's a pretty broad gross negligence standard. However, the public utility sector must have some really good lobbyists in North Carolina because the statute has a carve out where gross negligence doesn't apply to damage incurred by facilities or equipment that belongs to public utilities. So like gas operators or telecommunication services or electric power, any of those things. So generally speaking, gross negligence, however, not if you're damaging something that belongs to a public utility. So while gross negligence is new to North Carolina, certified burner training is not. They have had this since 1999. So despite just having a simple negligence standard, they were offering this training. It just didn't give you legal protections to go along with it. So the training has existed since 1999, and every year they told me that about 100 to 200 individuals are taking the course every year. But again, this is another state where most people who take the course don't actually go on to get the certification. They don't complete their training burns, and so they're not getting fully certified. South Carolina. South Carolina is unique in that its gross liability standard is for damages that result from smoke. So it's got a negligence standard for other things and a gross negligence kind of protection when we're thinking about damages from smoke. The training that individuals go to for that protection is a one-day course. It's not intended to teach individuals how to burn. It is really just a training to teach them how to manage smoke in order to comply with South Carolina's smoke management guidelines. So kind of an interesting, when you think about gross negligence, it doesn't necessarily mean that it's gross negligence for everything, right? States have done lots of different permutations. All right, our last state here, Washington. So Washington launched its certified burner program in 2022. Certification is not required for individuals to conduct burns, but becoming certified provides you with those liability protections, right? So the statute says that no civil or criminal liability can be imposed upon individuals that have that certification unless there's proof of gross negligence. So it provides pretty broad protection there. All right, so that was kind of the work that I've been doing, is looking into those programs. And the reason I was doing this was, we're thinking about like, all right, if we were to try to think about legislative fixes and we're wanted to make changes here in Idaho, what programs are working? How are they working? Might they be effective here? And so what we wanted to do next with this part of the presentation is do a handful of little polls and surveys. So this is your like authorization to use your phone or your computer or whatever you have handy. You can scan that QR code, or you can go to that website directly, whatever is easiest for you. And I'll stay on this slide so you can get that QR code or that website for a moment. And then the first poll is on my next slide. But essentially, we're going to run through a handful of polls, and we're interested in seeing what, reading the temperature of this room and what you all would think would be meaningful, and what maybe are barriers here in Idaho to using prescribed fire. Idaho is an interesting state in that we're both fiscally conservative, and then there's also a lot of legislative pressure or desire to have fewer and fewer regulations, right? And so I'm not sure what's really in the realm of possibility when we're thinking about those sorts of constraints. But I don't want you to think about those sorts of constraints. I'd love to know what your like wish list is. All right, so hopefully we are logged in. Here is the first poll, and it's really a ranking thing. You should be able to slide or move these items up and down. So your top should be what you think is the biggest barrier to the use of prescribed fire. And what you end up putting at the bottom should be what you don't consider to be a significant barrier. So you'll just kind of rearrange these on your own screen. You can submit it when you're ready.
You tap on the thing, then the arrows show up and you can move them up and down.
Yeah, I was playing with this on my phone. I kept trying to drag and then I would refresh, and that was not the correct thing. So yeah, you have to like tap on each item and then you can move it with the arrows if you're doing it on a phone. I can tell that 2 of you have answered. So like, kudos to you for figuring out the technology. I promise it'll get easier on each of these as we get better. So Heather, how many people do you have in the room there?
Probably about 20, and then there should be another 10. Online, there's another 14.
Yeah. And I recognize maybe not everyone wants to play along. So I'll wait for us to get to maybe around 20 responses, and then we'll move on. All right, I think we're slowing down. Does anyone need me to wait, or should we go ahead?
I can go ahead.
All right. So
But keep on filling it out if you're still working on it. So we'll
feel free, yes.
ask questions.
So it looks like what are people who answered. So top is liability for damages to property, followed by resources and equipment as a barrier, potential suppression costs, potential smoke impacts, knowledge, money, injuries to people, and time being the least barrier. Okay, let's try another poll. So how likely are you to use prescribed fire currently? 5 being I have no issues doing this and whatnot. 1 being it's not something that I'm comfortable doing, it's not happening.
And will that, oh, I see, I refreshed the screen, so I dragged my screen down and then refreshed it to get the question.
Thank you. I was wondering.
So if you have this, it looks like we're up to 15 or 16 responses. I'll give you all another moment. I love when the number goes down. Y'all are like assessing, changing your mind about your comfort level. All right. Let's go back and look at the responses. So we have a few people who've answered not happening. Oh, excuse me. But almost half of you saying that you don't have any issues using prescribed fire. All right, turning to our third poll then. How likely would you be, and some of you are already like so fast in moving through this, but how likely would you be to use prescribed fire if there is an insurance claim fund to cover costs for damages less than $1 million? Let's look at where our responses are. So that does seem to have moved the needle, right? Because as a current matter, we were at just under 50% for people choosing E on the last line, and we had some people saying it wasn't happening, and now it looks like everyone's maybe moved up a little bit from that position. So that does seem like something that might move the needle. Here's another question for you, right? So how likely would you be to use prescribed fire if there was a gross negligence standard in Idaho, where you wouldn't be found negligent if you were using reasonable practices? All right, so let's see where our results are. So that similarly seems to have increased things, and maybe even more than the last option. All right, let's take another poll for y'all. So this one, sorry, I think we might have gone backwards. Let's see where we are. So we have the claim fund, we have this one. All right, there we go. So how likely would you be to use prescribed fire if you were paid a modest amount for the area you burned?
This would be thinking about yourself on private land. So if you were a landowner using fire and you were able to get some money for the work that you're doing on private land, on your private land, not for your job. Ideally, you're getting paid for your job.
Without the other incentives or protections?
This is without.
These are building. And
Yeah. So
they're
this is like just like, so from what we have now and add, the only thing added is now you're getting paid. So without $1,000 or $1 million claims fund, without gross negligence, the only thing being getting paid for your work.
So let's see how many answers we have here. It looks like we're up to about 15, which is where we've been. So this similarly is moving the needle a little bit differently. And I'm just gonna go, y'all, it seems like my poll skipped 2 questions. So I'm just gonna play around with this for 30 seconds and see if they will show back up for me if we, so How likely? How interesting. All right, well, let's go ahead and I'll have you enter this and then I will try to get my slides that are hiding back for the next one.
Like the question kind of trails off there, or maybe I turn my screen. Oh yeah, that worked. So if you turn your screen this way, it'll show the full prompt there.
We're up to 15, so let's see where our responses are. So people indicating that liability for damages or injuries being their biggest concern, then for costs related to suppression, and then for damages or injuries to individuals associated with the fire. All right, y'all, I'm gonna try to find these slides that are hiding a little bit right now. So let me I'm sorry, I'm gonna close this and restart this with the slides that I've skipped. Okay. So let's try this one. So it's kind of the same question as Heather kind of posited it, like what would this do? You know, assuming this was the change, we're not stacking them on top of each other, but would this move the needle for you? I know earlier when we were ranking inhibitions, I think equipment actually came in relatively high on that list. Let's see where we are for our responses here. So, yeah, moving the needle a bit for sure. It seems like all of these things are all hitting that level at some point. All right, and then our last one, hopefully this cooperates. There you go. So, so similarly, kind of taking this in isolation, how would this impact your feelings? Let's go ahead and see where our responses are landing. So training being what looks like a pretty big draw as well. All right, so we're going to try to skip a couple slides that we've already answered for some reason that it didn't like before. Here's our next one. So this is our last ranking question for you. It's kind of, what do you think is the highest priority? So this will be like that first question earlier where you have to not refresh your screen, but tap on a box and move it up and down with the arrows. All right, I'm gonna go ahead and show the responses we have so far. If you're still answering, please feel free. So, highest priority, gross negligence standard, followed by insurance claim fund, certified training program. Oh, excuse me, trailer with equipment and possible payments for the use of prescribed fire. Okay, the last survey question that we have for you, and this is like a typing kind of response question. But essentially, what do you think that legislation regarding prescribed fire should include? What do you think would be a priority? All right, I'm gonna go ahead and show answers, but you can certainly keep responding. A lot of common themes here. All right. So I'll let this roll for another few moments. My next slide just says questions, although I'm definitely short on time. But if anyone has any questions for me, anything that I can answer while I'm still here, I'm happy to do so.
No, Jessica, you gotta get going here, but we really appreciate your time. Thank you, and we'll use these responses as we continue the discussion.
Sounds great. All right, thanks everyone for your time today. So.
Thanks,
Yeah, thank
Jessica.
Thank you.
Thank you, Jessica.
Sarah, I believe you're still on. Are you still on?
Yeah, I'm still on.
So just wanted to finish up this discussion with discussion. So, I know that we talked, Sarah, about like how then, so if we've got ideas, if we've got like things that we feel like are important, how do we make traction on any of that? And, I feel, was it you, Sarah, that was, or maybe it was Jessica that was talking about, a group whose responsibility it is to write policy for people. Is that, do you remember that conversation?
Yeah, that was Jessica, and there's actually, the state of Idaho does have a group of individuals that finalize draft legislation. So what I gathered from Montana, because they have the same thing, is we would draft up some legislation and then hand it to them, and they would, clean it up and get it ready for actual review and publication, I suppose, in whatever the legislative docket or something. I don't know how that all works. Sarah probably does, but I don't.
Is there any insight that you can give us, Sarah, about what that process looks like to make adjustments to legislation?
Yeah, so I am not deeply familiar with Idaho's legislative system in the way that I am in California. What I will say is in California, having a lobbyist was incredibly helpful. So someone who knew their way around the Capitol, and frankly, who we were using was folks that TNC had in California that were kind of providing the outer parameters of how to do this and who to talk to. The key for us was finding one state senator who then drafted basically all the bills that I talked about. And really, it was just that we found one staffer in one key office that wanted to work with us. And then that is how we got it done. But I think you have to find that door open first to find your legislative advocate.
And in California, Sarah, it's not like it was sponsored by a state agency, right?
No.
Like in Montana, the DNRC is sponsoring that legislation. So
Yeah.
Archie, I know you have your hand up, and my question to you is this something that IDL would sponsor? Does it go better when it's not sponsored by a state agency?
Well, I could be mistaken here, but I don't believe state agencies are really allowed to quote unquote sponsor bills in Idaho. We are most definitely not allowed to, and I'm air quoting on purpose here, lobby. You know, there's backdoor ways we get stuff done, but you know, we know everyone else is lobbyist and can talk to them. But I think one of the things, I mean, the best way, of course, is to find a legislator that would be amenable to what we're trying to get them to do. But the other thing is we do have brand new legislation this year. It's called House Bill 14. And what it does is it requires each state agency, much like we did a couple of years ago with the governor's zero-based regulation executive order, where each agency had to take its rules and essentially vacate the rules and rebuild them from scratch to shrink them down. Well, House Bill 14 now asks each agency within the state to do the same with their statutes. So the first level was rules. Now we're doing the statutorial level. So we, by September 1st or September 30th, I can't remember the date for sure. I think it's the 1st, have to put together a list of statutes that we think are either antiquated, out of date, unnecessary, or in need of update. And so it should be specific to, you know, our fire rules, or our fire statutes, or our forced practices statutes. But that doesn't mean we couldn't tweak something. So yeah, House Bill 14, I think is kind of it might be a good vehicle to get the discussion started. That's probably not really what it was intended for, but they opened the door. So, you know, if the door is open, you walk through it and see what hits you on the other side. So I would say the best way is probably still to find a sponsor, but House Bill 14 opens the door. So.
Okay, so I love that. I just don't know who's walking through the door. I don't know how to do that part of like then.
So that's the scary thing for us
Yeah.
too, is whatever we bring to them, that House Bill 14 requires is that we bring them the statutes and we can provide suggested language. But once they open that statute, who knows where they're going to go. So you have to be cautious and deliberate about what you choose to bring before them. So we will be talking a lot about this internally this summer. You know, what do we want to bring up? What don't we want to bring up? So, yeah.
Yeah, Bob.
From a policy standpoint, we could certainly work on something. You know, Archie has some ideas, and we can get our government staff together and I'm sure we have policy in our book that could probably support it.
From the Idaho Farm Bureau. I love that.
And
That's
if we
great.
don't, we can work it.
Mhm.
They are allowed to lobby.
I
And
would recommend
okay.
aligning this with the committee that it's gonna fall under, so like this would be a natural resource, it's got a probability.
Right.
You're gonna want to look for a response with the natural resources.
Right. Yeah, I mean, just my like loose familiarization with what other states are looking at is that they do have like specific people that bird dog this stuff within the council. So I don't know who's got this paddle, but I just keep on, if I grab this paddle, it's like doesn't fit in my hands. So we're like one of those puzzle pieces that doesn't go into this puzzle. So it's gonna, and this is kind of the same case with anyone on the executive committee. I don't think any of us are really finding our own, like, there's gotta be a little bit of native ability. It feels like, I don't know, if that's just me, but like, I don't know, I feel like this is gonna need to be something that we'll talk about more tomorrow, but we are gonna need some help from within the council. And feel free to volunteer anybody, that's got some abilities here. It's gonna need to take someone with some concentrated attention and a little bit of, again, native like ability to understand and follow through with things like this. So that's, yeah, I'll just, in case you're thinking that we're gonna do it, you're wrong. We're gonna need some help to figure this one out. Yeah, I don't know, and I remember talking to you, Sarah, about this, how this process worked, and at some point it just does, like, it comes down to somebody just being like, just starting it and getting this language down, even using some chat GPT to start something and get some thing begun. But the states that Jessica presented there, they at least will have some starting language. And so we could start from existing language that's already gone through other states at least, and we could put those things, you know, specifically, like, we can go shopping. If that South Carolina one had some really interesting smoke specific ones, and that's a big concern for a state, then like, let's see what they have. Maybe we can use some of that. So we can try and work smarter, not harder, when we're thinking some of these suggestions.
Yeah, I would suggest that. One of the other things that I've learned in working on both state and federal stuff is like having draft text is incredibly important, because you then, I mean, you both don't really know what then happens to it, but you need the text to have someone actually pick it up and be like, oh, now I understand what you were talking about. And so like setting as an interim goal, just like getting some ideas to whatever this ledge council people that will help you seems like a really good one. So you can then have text that people can float around. The other thing I'd say, and I couldn't quite hear the person in the back, but I heard Farm Bureau, and I did just want to note that I think one of the reasons we've been incredibly successful in California is that we have a very strange and robust coalition, which includes Farm Bureau, Nature Conservancy, California Cattlemen's Association, 2 federally recognized and 4 federally unrecognized tribes, like a bunch of resource conservation districts. It's just like a very across the spectrum kind of coalition of folks that, if not intimately involved on a day-to-day basis driving it, were supportive and early sort of signers on to draft legislation, and that's been really helpful.
We have, I have as a goal for tomorrow to draft some stuff. Just to like, why not? Why not try and make some language that could work for this? And so that's one of the goals we've got tomorrow for our policy working group after we do a little burn plan morning discussion. Another one that came up that we talked about today was just making it like a little bit of a clearer list of like step by step. We have this before you burn thing, but you know, as we brought up today, we're like, do you need a burn plan for that? I'm like, wow. So let's try, like, there's some things that actionably we can actually get done tomorrow, which is making clear expectations about burning and the circumstances around that, and then also just giving it a go. I think it's got to start with some darts thrown at the wall to just start to line out what we would even want. And you know, Sarah's kind enough to be involved here with the support of the Fire Learning Network. Emily Holman's on from the Fire Learning Network, and that Sarah's involvement with us at all is because of work from the Fire Learning Network that's put Sarah on as a retainer to do just this. And so it's a real benefit to have this additional expertise, not to write our policy for us, but at a minimum, you can send stuff and just be like, are we even in the ball field with the words that we're doing? Like, what I think the reason that way I asked it to Sarah before was like, just like, you don't need to interpret the state legislation for me, but just could you read it like you were reading my palm and be like, what does this say? Like, just give me some just woo-woo of like, what, is this good? Is it bad? Is it like, what are we, what are we up against here? So similarly, I would just we'd send this around to a variety of people just to say, what would happen if these were the words in our legislation, in our policies? Okay, any final questions for Sarah before she's gotta go?
Yeah, Sarah, just one quick, this is like a process question for you. When you were drafting that original legislation in California that representative then took on, did the draft get shared out to agencies or like land management agencies and CAL FIRE first? Or did you just?
We have a very segregated process. It sounds similar to what Archie was describing in Idaho, where technically agencies are not permitted to lobby. And we, at the time we started this, had some pretty reticent folks at CAL FIRE for the ideas we were pursuing. So we forged ahead without agency feedback. There's pros and cons to that approach. We eventually got it by way of like these weird, Archie alluded to, there's back channels that agency folks have to try and get their voices in the room. I'll say, as we have moved forward in time, our most recent bills, we did have some like very extensive back and forth with our state agency folks. We did a cultural burning sovereignty bill this past year and like worked extensively with the California Natural Resources Agency on it. So don't tell anyone I said that out loud because I'm not supposed to, but so there's you should first understand what the parameters are in Idaho for how much your state agencies can be involved. But I do think there's benefit to trying to get some early feedback so you don't inadvertently create barriers that you didn't know about.
Good. All right, thank you so much for your time, Sarah. We appreciate it.
Yeah, of course. Good luck.
Thank you.
Take care. Bye.
See here for draft legislation claims fund plus 13. Oh, thanks, Parker. Parker, where'd you get that at?
I'm from Colorado. Hey, everybody. Parker Titus, Fire Program Manager for TNC Colorado. Didn't want to miss Sarah's presentation, and I'm a fan of your Prescribed Fire Council way down here.
Oh, thanks. We have fans in Colorado, everybody. That's so fantastic. So this is the legislation that you guys have drafted?
Yes, that's right. And thinking about our process here, I am also a board member of our Prescribed Fire Council, our workshops next week. How we move this through in Colorado, we have between sessions, there's interim legislative committees where they have special interests. We have a Wildfire Matters Review Committee, and through that body, we can present on topics of interest to them. This year, we took the opportunity to present on prescribed fire, and then through that opportunity, seeded the idea of a claims fund, which ranked out pretty high here in Colorado as a practitioner need. Love that exercise that we ran through here to sort out what is valuable for you guys. And through TNC lobbyists and other indoors we were able to find some interested ears, and TNC, along with Western Resource Advocates, and then Fire Adapted Colorado drafted some legislation. We basically built the wording, provided that to the bill sponsor, who through their interim committee presented it, and then the committee voted as, yes, we want this to be a committee bill, and on it moves into our regular session. So we have some wind at our back, the claims fund and this other piece. It's making its way through the process. So far, so good. Happy to talk more in the future off channel about how we're doing this.
Okay, great. Great. Okay, well, I think that what we're gonna do now is close. And then we'll just mill. So we'll be here for a while. Like, feel free to whatever, come and go, but we'll be here for the next hour. And I'll be here for the next hour. Just let's have some of these discussions if we want to start to think about what our next steps are. Any questions, thoughts before we break the day?